Hey guys, today we get a major update that just released on TED Entertainment, which would be Ethan Klein versus Morgan. So, if you are to believe H3 Leftover, which is the reincarnation of H3 Snark, then Morgan was not served. If you were to believe some people on Twitter on the Hassan's orbiters, Morgan was not served and she was winning. Well, that turned out all to be false, like I said it was. She was served substitute service, and now she has a lawyer. So August 5th, stipulation for extensive time to file answer to October 3rd via complaint, attorney civil case opening, one filed by plaintiff TED Entertainment Inc. Essentially, Frogan got a lawyer. Lawyer reached out to Ethan Klein's lawyer and said, hey, I just got hired. Do you want to do me a favor and not make this too messy? And Ethan Klein's lawyer said, yes. As a professional courtesy, lawyers will do each other favors because you never know when you're going to meet that, especially since this is an IP lawyer. And we do have some information. In fact, this IP lawyer is on YouTube. He is a trademark and copyright lawyer, which is, again, as I've explained, patent lawyers are the top dogs, and then everything else is just kind of like whatever. So, whereas on June 19th, 2025, Plaintiff TED Entertainment, TEI, initiated the present action by filing its complaint for direct copyright infringement against defendant Morgan Frogan, docket 1. Whereas on July 18th, 2025, TEI filed a proof of service for serving the complaint on Frogan on July 14th, 2025, docket number 12. Whereas on August 1st, 2025, counsel for Frogan contacted counsel for TEI by email to contest the validity of the service of the complaint on Frogan. So there you go. Frogan hired a lawyer. Lawyer contacted TEI and said, hey, I don't believe in the validity of service, but whereas in the same email, counsel for Frogan offered to resolve the issue and avoid unnecessary motion practice by having TEI withdraw the July 18th, 2025 proof of service and having Frogan execute a waiver of service pursuant to Federal Rule of Civil Procedure. So we don't think that you served us properly, but we're ready to get served today. Rule 4D and receive an additional 60 days to respond to the complaint pursuant to the FRCP rule. This is quite fascinating. These timelines are moving at different paces. Denon's timeline is moving very fast. Casey Tron somewhere in the middle. Frogan is way behind. Assuming she takes the entire 60 days, she will be way, way behind. Whereas on the same day, counsel for TEI responded to counsel for Frogan without conceding the validity of the objections to service, expressed agreement regarding avoiding unnecessary motion practice regarding the service of the complaint. So TEI, the counsel for them, said, no, our service was okay, but we're willing to, quote, settle with you on this dispute. As in the same email, counsel for TEI offered to streamline the resolution by the issue by granting Frogan an additional 60 days to respond to the complaint. So TEI, the counsel, is still saying, we served you correctly. Frogan's counsel is saying, you didn't serve me correctly, but I'm willing to be served correctly today. Whereas counsel for Frogan agreed to this arrangement so long as Frogan preserves her right to file any responsive pleading pursuant to FRCP Rule 12, with the exception of contesting service under FRCP Rules 12B, 4.5, and counsel for TEI agree. So part of this agreement is that that the service was served to you properly. You cannot contest it. Whereas good cause existed for the stipulation because 1, it resolves the parties' issues concerning service, 2, conserves the time and resources of this court, and the parties by avoiding unnecessary motion practice. They would have to probably spend another few $1,000s battling this just to reach the same conclusion that, yes, she was served. Therefore, it is hereby stipulated by and between the parties through their respective attorneys of record that this court grant the stipulation to that Frogan's deadline to respond to the complaint be continued from August 4th, 2025 to October 3rd, 2025, that Frogan can respond to the complaint with any responsive pleading pursuant to FRCP Rule 12 with the exception of the contesting service under FRCPR Rules 12B and so on. And the court entered, so she actually can respond, right? It is interesting. It is quite interesting because Frogan now has a lawyer. So we will look at the actual request and then we'll take a look at the lawyer. The lawyer is different. So remember, Caseytron has 3 lawyers. One of the lawyers is shared with Denons. So Denons and Caseytron share one lawyer, but 2 of Caseytron's lawyers, the Provice Hawk. Sorry, my baby is screaming like crazy right now. It's really hard to make this video. Sometimes when news drops, it is just, news that you have to cover regardless, right? So in this case, the Frogan has a completely, entirely different attorney from any of them. So Caseytron has 3 attorneys. One of them is kind of like in CoffeeZilla. It's just an attorney that sits there and allows the other 2 attorneys to come in under his license. The other 2 attorneys work for the same law firm as the one attorney representing Denons. That's Caseytron. So Caseytron has 3 attorneys. 2 of them work at the same law firm as the one attorney representing Denons, and one of the attorneys is actually representing both of them. Here, what's unique here is that the Frogan's attorney is completely different. And Frogan will not need, this isn't like Caseytron. Caseytron's in Missouri, so she needed a different attorney to bring in these 2 other attorneys. Frogan has gone with an independent attorney. So the attorneys that both Caseytron and Denons have gone to are larger law firms. They are a larger attorney in terms of volume of cases they do and so on. The attorney Frogan has chosen is a attorney that is just one person, I believe. One attorney, from what I gather from the website. His name is Braha Nika, and the website is nikalaw.com, I believe. Yep, Nika. It's hard to spell. Niknialaw.com. And it has only one attorney bio. Braham Nika is the founder and principal of the Nika law firm. Braham's practice is focused on areas of trademark, copyrights, and litigation. Prior to forming his own law firm, Brahma was the general counsel to Bruce Brown Films, LLC. Brahma handles commercial and intellectual property litigation and represents businesses and individuals in a variety of transactional, trademark, and copyright matters, including business formation, trademark, trade name registration, and contract preparation. Before going to law school, Braha owned and managed and operated several successful businesses. Today, he draws on this knowledge and expresses to effectively litigate matters on behalf of his client. Braham has successfully represented clients in all alternative dispute resolution forums, including arbitration, mediation, state and federal court, bar admissions, California bar, education, UCLA, for a Bachelor's of Arts degree in philosophy. That's why he cannot be a patent bar. So, side note, to be a patent lawyer, you have to sit for the patent bar. The patent bar would not allow an individual with a degree in philosophy to sit. It's only science majors, engineering majors, math majors, or you can submit with your courses and yeah. Practice area, trademarks, copyright, business litigation, class action, business transactions, contracts. It's interesting, right? They've kind of done a very different take on this individual. So anyway, that is it. It's been a pretty busy day with baby, so that's probably going to be, I'll probably make a longer video about this individual and what I think the credentials are for all 3 of the legal teams and their chance of success. Anyway, Let me know what you guys think in the comments below. Bye, guys.